Okay, we're officially recording, so we're going to get started now. I just want to thank everyone for coming today. I'm sure we'll have some more people coming in as we move forward, but want to thank you today for joining us today for our spring CLE program, Strategies for Representing Survivors of Intimate Partner Violence. I know from the list that many of you are already familiar with SHALVA, but for those of you who aren't, who are in attendance, SHALVA supports Jewish women experiencing the healing from domestic abuse through counseling, supportive services, and community education. Our legal liaison program is a holistic approach where the therapist, outside counsel, and in-house legal liaison work together with our clients to navigate the legal system. One of the other goals of our legal liaison program is to be able to provide continuing legal education programs like this one today to create a greater awareness around domestic abuse and intimate partner violence in our profession. We have a wonderful panel of experts here today. The Honorable Renee Goldfarb, Associate Judge with the Domestic Relations Division in Cook County. Rebecca Meltzer, who is a partner with Berlin Meltzer Law. Andrea Muchin, partner at Schiller, DuCanto, and Fleck. Kim Shapps, who is a SHALVA Therapist with both a JD and an LCSW. And Scott Tzinberg, who is the principal at Law Offices of Scott Tzinberg. So thank you all so much for your time today, panelists, and the organization that we've been doing up until the last minute to get this to be a successful program. So I'm looking forward to hearing from each of you. Today's format is a kind of a question and answer format with our panelists. If you have anything you would like to add or question, put it in the Q&A. That will be where I'm checking and monitoring as I moderate the program today, and we'll try and get your comments in. I emailed all the written materials ahead of time, but I will email them again afterwards along with a survey that I hope you will take a moment to fill out. And with that, let's get started. And I think our first question today is going to be for Scott. And Scott, could you tell us a little bit about what your client intake process is?
Sure. Yeah, thanks, Vicki, and thanks for having me on this panel. And hello, everyone. Obviously, the intake process, I think, has changed over the last year based on COVID and pandemic situation. So in pre-pandemic, where we could have the client come to our office and have some, make sure we have some privacy to go through issues with regard to their situation and the domestic violence. Now we're talking, doing phone or Zoom for the most part. And I think it's very important on the intake process to make sure that your client who is the victim of domestic violence has privacy when they are speaking to you, because a lot of times you'll get a phone call and you just call the person back, but you don't know what their situation is at the time. So I think it's always important for the first question to be, do you have privacy to talk now? And if not, work out a time to talk to them, because you're not going to be able to get as much of the crucial information and strategize with them if they don't, under those circumstances. So I think that's an important part of the intake process that I would like to, that I wanted to talk about to start off.
Okay, great. Anyone else have anything to add on that initial, privacy?
I think just making sure you're talking to the client, knowing if you could leave them a voicemail, you can email them if they have a shared computer, to ensure that their abuser isn't checking, especially when people are home. I think people are getting more back to some regular life right now, but just making sure that the parameters are set, like Scott said, about reconnecting with them in a safe manner.
Great. And kind of along those same lines, Andrea, who looks like you were getting ready to speak anyway, if you can talk a little bit about that intake process, which I think also ties in with the question for you, is how do you set boundaries with your clients?
I think setting boundaries is so important for all clients, but particularly for clients who experience domestic abuse in their life. And what I try to do is, from the very beginning, really make myself very transparent and accessible. I explain how they can reach me when they need me and when they can expect to get a response, so that they're not feeling like stressed about their contact with me, but they're also not taking advantage of feeling the need to reach out to me all the time. And I also, at the very beginning, suggest, particularly for clients who've experienced the kind of things these kinds of clients have experienced, that they get their own therapist and mental health professional, so that they have someone where they can discuss their personal feelings about what they've experienced with. I'll be there to support them, but I make it really clear to them that I can't be their therapist, and that will save them a lot of time and aggravation and be way more helpful. I also almost always ask for a release to speak with that client's mental health professional, because I want to make sure that we're giving similar advice and that we're working together to help this client. I try to explain very clearly what the divorce process is and what, if any, impact their personal experiences is going to have on that process. Because a lot of these clients think that everything that's happened to them should matter in their divorce, and they're very sadly disappointed when I tell them it may not matter. But I want them to understand what matters and what doesn't, and to know that I understand, even if it doesn't affect the process. And then when I've had some very serious issues when I've represented religious people who've suffered abuse, because they think the fact that they're religious should really affect the process. And that's a boundary that I need to explain to them very carefully, that it doesn't make them, really the process is just designed for everybody, and we have to work within that process that exists. And then I do also try to tell people right off the bat that even though I am very sensitive to their personal experiences, we need to focus on what's relevant to getting them divorced, because otherwise you will spend ages on things that you can't change. So those are my thoughts on it. Thanks, Vicki.
Great, thank you. Thank you. I think that leads very nicely into a question for Kim, which is about both Scott and Andrea have already talked about a situation where you're pretty sure that there is domestic abuse in the situation. So for you, Kim, what are some of the warning signs or I should say, how is it that you would screen for abuse during an intake as a therapist? And maybe you want to go a little bit more in, well, let's start with that one, actually. Let's start with that. So how would you screen for abuse during intake as a therapist? Like what would you want attorneys to see happen? Or what would you want attorneys to do is what I'm trying to say.
Yeah. I mean, so first of all, I just want to reiterate how important it is to screen for domestic abuse during intake meetings. You know, if you're not screening for domestic abuse, you could potentially be missing really important information for the representation of the client. So in terms of screening, rather than handing the client a screening tool with preset questions on it, the best way to screen for domestic abuse is just through a conversation. That way the client knows right from the start that you're a safe person she can talk to about this. And in cases where there hasn't been overt physical abuse, the client may not even recognize she's being abused, and she may not have the language to name what's happening to her. So while it's certainly important to ask her about physical safety concerns, you also want to ask open-ended questions that are just going to elicit information so you can better understand the full dynamic of her relationship. You want to be able to ask questions like, have you ever felt controlled, demeaned, intimidated, threatened by your partner? Have you ever been forced to do something by your partner that made you uncomfortable? Right? And remember that abuse is a cyclical pattern. It's behaviors that happen throughout the relationship and are rooted in a need for power and control. So you want to be able to distinguish between abuse that again occurs throughout the relationship and behaviors which may arise only very, very recently and that might only be a symptom of the breakdown of the marriage. And another important reason to ask about domestic abuse is that the information you learn may very well offer you a blueprint for what you can expect from the case. Now be sure to ask your client whether her partner ever made any threats about what would happen if she left or divorced him. Threats like, I'm gonna leave, if you leave me, I'll take the kids away and tell everyone you're crazy. those become a narrative in your case. Or threats like, if you leave, I will make sure every last penny goes to the attorneys and you'll end up bankrupt. Those are threats that he often tries to follow through on. So yeah, and then I'll just reiterate what Andrea said earlier, which is that if you do suspect your client is being abused, how crucial it is for them to have an outside independent therapist who's knowledgeable about domestic abuse, someone not connected to the case, and someone who can really help them to develop those tools to better manage and regulate their emotions.
Great. Thank you, Kim. Thank you, Kim. So next, I want to turn a little bit to Rebecca. And we've been talking a little bit about clients who are experiencing abuse. COVID, hopefully we're on the other side. Things are definitely getting better, but they're not there yet. How have clients been doing? Particularly clients in general, and the clients that you may be representing that have experienced abuse. How are they doing in these times with the Zoom hearings and all of that?
I think Zoom hearings have given domestic abuse victims and survivors a bit of comfortability when they are in their home, when they're not sharing a home with an abuser. But I think it also gives them some anxiety about, what does Zoom look like? Am I going to be left in a side breakout room with my abuser without anyone else present, without a sheriff there? How am I going to contact my attorney? What's the mechanism to chat with them during a hearing? And I think that preparation with a client is really key. So making sure the client understands what's going to happen. If you are going into a pretrial and you're left in a Zoom with your abuser, what are some strategies you can take? Can you turn off the video? Can you turn off the chat and just wait for your attorney to text you or let you know that they're coming? Some clients don't want them to see where they are, right? And so can you learn how to put up a backdrop or another screen? And so I think it's just taking those strategies to make sure that not only now is their environment safe, but that they feel comfortable despite the fact that they're on Zoom with their abuser. And then obviously making sure that if there is a hearing where they're in the same household, what strategies can you get them to get them out of the house for a meeting, for a hearing, and looking at those verbal and nonverbal cues in case they are uncomfortable and do need to get to a safer space. And then just like any hearing, I would be making sure that any abuse victim has their therapy appointment, whether or not it's before or after, or some strategies to help with, depending on what happens in the case, that they're still maintaining that self-care and that therapeutic relationship during the pendency of a case, even though it's still on Zoom, because it's still obviously a very emotional and stressful time, and we want to make sure you're taking care of that person, regardless of the fact that you still have court via Zoom.
It's a great point. Great point. It seems like everybody has given a big shout out for the therapist, which is so important. Judge Goldfarb, as a judge, we're talking about the abuse that we're seeing, and from your point of view on the bench, how does the evidence of abuse impact your decisions?
Well, for one thing, I'm mandated to make a consideration. I mean, in terms of whether it comes in as a domestic violence petition, a petition for order of protection, or whether it comes in terms of, someone who's getting a divorce, has divorced, et cetera. When we hold a hearing, we have to consider the evidence regarding any conduct that endangers the child, whether it's physical, mental, moral, et cetera. We must take that into consideration in order to make orders or enter orders that's necessary to protect the child. And one of the things is, what can a lawyer, do to talk to their client? A client oftentimes doesn't understand that it's not just physical abuse. In other words, if there is physical abuse with the other parent, and if the child is present or in hearing of what's going on, that can be admitted by lawyers in terms of possible mental abuse for the child or emotional abuse of the child. And I think that it behooves the lawyer to, if you have a possible abuser as your client, let them know that that's a possibility. They don't understand. I've heard time and again I would never hurt my child. And they don't understand that it's more than just the physical abuse, but we must consider in terms of parenting time, et cetera, whether or not supervision is required, whether or not, if there is parenting time, the exchange is safe. Do they need to be in a safe location? We oftentimes utilize police stations, just parking lots, not necessarily, and depending on the case. And then when there's communication, perhaps you as a judge has decided for now there is no parenting time in person, but there's visual on, Zoom, video chats, there's even telephone. And again, the abused parent, if the parent has been abused, how do they deal with this? In other words, if the child is old enough, they can go on Zoom themselves, but if it's a smaller child, so there's a lot of considerations, tons of considerations for a judge. And we must take them into consideration.
Great, and I think that's a key point, that the children, even if there's not physical abuse, the children are being harmed. And that's a whole nother topic that we could spend days on discussing as well, and a very important point. So thank you. Switching gears a little bit, the financial piece is kind of the big hairy monster in the room, I think. So it is the kind of thing that people don't really want to talk about, the money and how we're going to divide the money up, but it is crucial, and our clients are in some pretty dire situations when it comes time for divorce. So focusing on you, Scott, for a second, just even talking about the retainer agreement. How do you kind of handle the money up front, the legal fees, and how do you present that to the client?
Sure. Yeah, I think, one of the most overlooked areas of abuse is the economic abuse that often takes place in cases like this. Everybody's familiar with the physical, emotional, mental abuse that we see a lot. But the economic abuse, when you have one party who is controlling the money, and you have a client coming in and they're even referring to it as his money and not recognizing that this is part of the marital funds, I think you have to know what you're getting into from the start. That and knowing that your client, has a lot of trepidation as it relates to finances, may not be familiar with the finances. You need to be willing, if you're going to get involved in the case, know what you're getting involved with, and perhaps, defer the fees to potential contribution during the case. Interim attorney's fees, obviously there's mechanisms as part of divorce cases or parentage cases. And if the client is not able, doesn't have somebody helping them out, or doesn't have access to the funds immediately, but needs that domestic violence component and going to court, I do think, you need to have that conversation and be willing to get involved with it, knowing that you're going to be pursuing the fees later on. If you're not willing to do that, I don't think you should take the case, from the start, because it's just a component of this process. I do think it's important to be very gentle with victims on the financial part of it and the fees and going through the engagement agreement and explaining it, because they're coming in with already so much stuff on their plate, and then kind of throwing things out about having to come up with money or in a time sensitive manner, I think is just going to increase their anxiety in the whole process. So I guess the bottom line, what I'm trying to say is you need to be patient with your client, and you may need to be willing to wait until the case progresses a bit to get compensated.
Great. Anybody else have anything as far as to do with retainer agreements from the panel? Okay. All right. Thank you. I think that's great. I think it's important. I love what you said about the reference to his money. It really says a lot about, the relationship. And that's like one of the tips, that's a good tip to think about as you're doing your intake process. Okay. Andrea, we talked a little bit about this, but more specifically, what kind of rules do you have relating to kind of texting and emails that you would recommend for clients. I feel like this is a big one.
It always has been a big one, but I think with the pandemic, it's gotten to be a bigger one. I used to have a rule and I said, texting is so unprofessional. No client will ever text me. Well, the pandemic came and that went down the drain because we're all living on our cell phones. And as Rebecca mentioned, you're in a Zoom meeting or conference with your client and they need to have a way to communicate with you. And that just has become, for at least for me, the easiest way. So I threw out the rule of no texting, and now I text with clients way more than I want to. And I also do try to save the text because I worry, even with texting, like you need a record that you had this communication. So it's gotten way more complicated. But I will say, and one thing I've noticed a lot, particularly with these kind of clients, they'll show me a text or an email that they received from their significant other, and they'll want me to like believe that that proves their situation. And it's not that I doubt them, but usually it's very out of context. And I really insist that these clients in particular send me the entire chain that they're referring to. So I have a context of where whatever's being said came up so that I'm not misrepresenting or misunderstanding. And it takes a lot of my clients that are in these kind of very difficult situations a long time to understand why I want to see the whole context, but I think it's very, very important. And then I also would say that I recently, and I think a bunch of us that are on this panel, follow a certain website that deals with lawyers and stuff. And I read something that just sort of fit perfectly to me on this one. And it said, dance like no one's watching and text and email like it's going to be read in court one day. And when I read that, it was right around when we were talking about this program. And I thought, that's exactly what I try to say to these people. And I have clients that, even though, luckily I don't charge for every second of my time, especially in these situations, but I get to a point where I won't even let them send an email or a text out that I haven't reviewed, because the abuse goes both ways. Like they're feeling very, very abused by their partner. And so they send a very horrible thing back in reaction, and it really doesn't help the situation. So I see that it's always been an issue, but with the pandemic, it's even more one in terms of this. So to me, best practices, really think before you send a text or an email, keep an entire stream together when you're trying to use it to demonstrate a point, and respect your attorney's privacy at some times so that it's not 24/7. Those are my thoughts.
Andrea, I don't know if you see this, but I was thinking this, like people tend to think that they have to respond to texts when they come in, as opposed to emails where I read it and I put it aside. And I'm like, just because someone's texting you right now does not mean that you need a ping pong response. And I think people are so tied to their technology, especially right now. It's like, okay, take a moment, draft it, keep it as a draft, and then respond. I actually can't stand text. I'd much rather message clients or email. And I think it's a better form of communication for us as lawyers to be able to present it to the court anyway, compared to text messages. There's sometimes a delay with when texts are sent and received, and it can kind of be misconstrued what you're responding to. But I definitely tell people, like, take it, review it at the end of the day, and then respond, right? It's almost like when you're shopping and you have a purchase in your cart you're unsure about, like, just wait till tomorrow. It'll be okay. And it will help people be able to process the information they're receiving without reacting.
I agree with you.
That's great. And I'm gonna that makes me think of something else that I think I want Kim to weigh in on, which is kind of the client side of things. They are in a heightened state of stress and expecting a immediate response to everything. Otherwise, they're convinced that something is horribly wrong, which, given that that they're dealing with trauma, is not surprising. But do you have any thoughts on that, Kim, on from the client side? It seems like it really does go back to managing those expectations right from the start.
Yeah, I think a lot of it is managing those expectations from the start. We refer a lot to trauma-informed services. And what we mean when we say trauma-informed services is really being able to be sensitive to the client's trauma experience and put it at the forefront when engaging with the client. And so I think with some of these things, especially like communication with a client, she really needs to know that she has a voice, So many women who have experienced abuse have spent years having no voice, having no decision-making ability, and feeling absolutely powerless in their own lives. And so whatever you can do to give her a voice is going to be helpful with her. You know, it can be really frustrating when a client calls repeatedly, but the more that you ignore her phone calls, the more anxious and the more escalated and the more re-traumatized she becomes by the process. I also think clients need predictability. They need to know what they can expect from you. They need to know what they can expect from the legal process. Any sort of predictability or routine you can give her is helpful. So letting her know when she can reach you, letting her know if you email me, this is the time frame when I'm likely to get back to you. So those kinds of things can be really helpful for a client. Being reliable. Trauma survivors often expect betrayal and disappointment from others. It's what they've known their whole lives. And so being able to be reliable, to follow through with responsibilities and commitments and appointments, and again, to give them a reasonable framework for when you're going to get back to them and when you're going to respond to them. And it doesn't have to be immediate, but if they know kind of a general idea of how you operate in terms of communication, it's so helpful to them.
Great, thanks. Thanks. Okay, I think we're gonna bounce it back over to Scott for a second. And I think that a lot of our panelists are gonna wanna weigh in on this particular question, so that we might spend a little more time here. We touched on it a little bit, but how do you explain the impact of intimate partner violence or abuse specifically on family law decisions? We talked about this a little bit, but, and I guess maybe I feel like we keep coming back around to the same topic, which really is about managing client expectations. But how do you explain that to your clients?
So I think, the domestic violence relates to a number of issues in our cases and divorce cases. And so it relates to child-related issues. It relates to the domestic violence order protection issues. And then obviously it relates, it could relate, or the clients want to know how it will relate to financial issues, including division of property and maintenance, child support, and things like that. I always hate to just come out and say, when you have somebody and they're, in a desperate situation, and just say, well, everything that's happening to you really is going to be irrelevant in the divorce case. Because I think that really, saying it that way, and I don't think anybody actually says it that way, but if even if you try and say it a little bit differently, I think it's sort of like a big letdown that everything that's happening is really not going to be that important as part of the divorce case, because there's this formula, that formula. So I think it's important to first point out where it is relevant. So we already talked about as it relates to protection of children, even if the domestic violence is directly to the partner. And I think that gives everybody, gives a client a little bit of, confidence in what's going to happen. And as it relates to the financial parts of it, I do think it is relevant to, again, with the economic abuse, in getting that person some sort of financial stream of money coming in. So I think it is relevant if you have an economic and financial abuse situation. It is going to be relevant when you go to court and tell the judge that your client needs some sort of stream of income, so they're not relying on, an allowance, as sometimes clients refer to it. My husband gives me this allowance, which again doesn't seem like it should be appropriate in a marriage situation. So you want to explain that there's no allowance here. This is your money. This is your money, and so it's going to be relevant to getting them support, getting them contribution to fees, to child-related expenses. If you're talking about excluding a spouse from the house, like an exclusive possession situation, and the client's going to be very concerned about how are the bills going to be paid if that person is leaving, and you want to assure them that that's going to be part of the process, and getting some of those funds that are in control of the other spouse are going to be involved. So I think explaining to them that it is going to be relevant to some degree, maybe not relevant to the amount of maintenance that might be calculated at the end of the case, or the amount of child support, because those are through formulas. You know, you're going to have that conversation, but I do think explaining to them how it will be relevant. And even when it comes to dissipation type issues in divorce cases, oftentimes you might have a domestic violence situation and a dissipation situation at the same time. And you could explain how that's going to be important and relevant at the end of the day.
Right. Judge Goldfarb, I feel like you might have something to add on this topic of the financial piece.
Well, okay, because I was going to say, in many cases, whether we're dealing with domestic violence or just regular divorce, well, let's say domestic violence, each party wants me to punish the other one. They want that to happen. And their lawyer has to explain to them that's not any part of the formula in terms of punishing them. And I'm going to digress just a bit. When we were talking, when Becky was talking about being on Zoom, it's a little bit more informal. And so people who are so emotional find it, they have to say something. And oftentimes it's, for instance, I've had a few times where we're talking about something and he or she will say, but 2 years ago he did, and it just starts talking. So for me, and probably to the chagrin of all lawyers,
right,
I now see the dynamic between the parties. I can now see, you want to know what it looks like? Well, I can now see who is a domineering person or attempting to be domineering and how the other party is reacting. And I have seen literally the other party sort of shrink. You know, so I see a lot of things like that, but back to what you said, the people have to understand that we are not there to punish them. We are there to do A, if there's children, what's in the best interest of the children, and B, what is fair to this family, period. So that's our goal. And you could say it 1,000 times and I'll still get, and the only really good thing about this for me is I have a mute button.
Oh, that's funny. I like that. Okay. Andrea, you had a comment on this financial piece?
Yeah, when Scott started talking, he mentioned financial abuse, and I've always known about it, but I have a current case where it's so prevalent, and I wanted to give an example.
Please do.
Maybe some people on the call. I have a case where the people have very significant means, and I have the woman, and I knew she had been emotionally abused in her marriage, but the husband, claimed he's the greatest because he pays for everything. And a couple months ago, she called me up about 2 bills, and one was to my law firm and one was to school. She enrolled as an undergrad, as an adult woman, because she never got a college degree. And the bill to my law firm was bigger than the other bill. And I said, just put them both on the credit card. He seems to pay everything. And this man went crazy. And I really thought it was over my legal bill. And I found out that it wasn't my legal bill. It was her school bill, because he didn't want her to get educated, because then she might understand how abusive financially her life had been. And it was it was the biggest wake up to me, because I thought, this is to the depths of her little $4,000 college bill is what set this man off, because he liked the world where he could control everything with the money. And we are set before a judge on Wednesday next week for a support hearing. And as much as it would be easy to say, keep having him pay everything, I'm going to fight hard to get her the right to pay her own bills, no matter what the bill is, because otherwise the abuse financially really, really affects people.
Wow, good point. Rebecca had something else to add. Thank you, Andrea. That's
Sure, it's a little bit different than Andrea, but I do have to say that I think that what Andrea is doing is amazing, because I think that what it does is it empowers women who've lost some power to be able to own their decisions and how to manage their life. And obviously part of our goal in divorcing to people is allowing them to be able to move on and become financially independent themselves. And I think setting the stage of that during a case can help reduce the direct contact of abuse and using that financials. And then going back to what Scott said about setting expectations, and actually also what Judge Goldfarb said, I think many of abuse survivors feel like they want to punish and they want to be compensated for their abuse. And they want to get that out of the division of the estate or get more maintenance. And I think it's really important to set those expectations also from the beginning, to recognize what a court would do or not do, so that they can help manage those emotions through therapy or through other self-care means, so that it doesn't come out in court speaking up in a divorce case or something else. Because I don't see judges saying, well, you're going to get 75% of the estate because it was an abusive situation, or you're entitled to this amount of money because you entered into a bad prenuptial agreement. And so I think it's just sort of, again, it's just all about kind of setting what the boundaries are. And sometimes it's repeating those with the therapist on the call, repeating those with a family member on the call, or making sure that you're kind of presenting it in different ways for the client to hear it. Because I think the worst thing is for them to get disappointed again by the litigation, right? Maybe be thinking an outcome might happen that might not. And so I think just being frank and forward from the beginning is helpful.
Great. Great. And that kind of ties in, Kim, we had another question for you that kind of goes about along the same lines, is how do you deal with a survivor who feels that they've been abused by the legal system in this way, where they feel that the financial outcome hasn't been fair? Is there more to what you've already said about, setting expectations and understanding where they're coming from? Do you have anything more to add to that? And then somebody asked a question in the Q&A that I think is in some ways relevant to this. So I haven't forgotten you. I'm going to come up with that in a second, but I want to hear from Kim first.
I think because the legal system is so often used by abusers to further the abuse of their partner, I think it's really common for clients to feel abused or re-traumatized by the court process. Many clients do have horrible legal experiences. They can be left financially bankrupt. Their parenting time with their kids becomes significantly limited. They feel that their partner is not following court orders and not being held accountable. And so years of ongoing legal abuse triggers feelings of trauma for a client. What we know is that when a client experiences great stress, the body's fight, flight, or freeze response becomes activated. And normally our nervous system experiences stress and then returns to normal once the threat passes. But if you're involved in a legal case that goes on for years and years and years, that nervous system can get stuck either in the on position, where the client becomes overstimulated, anxious, angry, and panicked, or in the off position, where you might experience her as being depressed, disconnected, fatigued. You're going to see in your cases that fight, flight, and freeze response when a client becomes re-traumatized by the legal process. Some things you might see are, first of all, a client in fight mode. That's your client who's anxious, who's calling constantly, sending a gazillion emails. They want to fight and they get angry when you're not fighting hard enough or fast enough for them, right? The client in flight mode, that's the client who says to you, I'm done with the case, I want out. Give him anything he wants, I just want to walk away from this. And clients in freeze mode, these are clients who take weeks to respond to your emails, because as soon as they see your name pop up in their box, they freeze and become terrified. Or the client who tells me that every time they hear the Talking Parents app ding on their phone, they become completely immobilized, knowing that there's a message from him waiting for her. Okay, so I think if you have a client who's re-traumatized by the legal process, again, you want to remain calm and kind to her, which in turn is going to help her feel calmer. And again, we already discussed giving her a voice in the process, giving her some decision-making ability, returning calls or emails, setting realistic expectations for her, setting boundaries for her, and making sure she has a therapist, all ways to help her kind of re-regulate her nervous system.
Great. There's a science, there really is a science to it, as well as best practices. So with that, I want to Rebecca, you made your comment?
Yeah, I'm good. I think I'm pretty good. I think we have a question in the question answer about our family wizard. Are you going to address that?
Yeah, there was one about family wizard, but now I have to go back because someone else put a question in.
Oh, yeah, Olivia did in the
Olivia
chat.
did, and now I'm trying to get back to it. So give me basically it's about the proposed change that would prohibit survivors from having to pay maintenance to their abuser. Here we go. What are your thoughts on the proposal in Illinois statute that would prohibit forcing a survivor of domestic abuse to pay maintenance to their abuser? It kind of relates to what we've been talking about, and this writer acknowledges that it is seemingly reverts to some fault divorce grounds. So anyone want to take that on? Judge Goldfarb is not going to touch that one for sure. I know we've had some conversations about that. Anyone? It's not. Andrea, you want to take it for a second? Andrea, you want to take that one?
I said I would be happy to address that. I'm not as familiar with the legislation, but just thinking about it here, I think it would open a huge can of worms, taking us back to the fault ground concept that Illinois has spent many, many years getting away from. On the other hand, I think it's like a concept that has to be recognized as part of a case without getting into prohibiting or allowing something. And I think, just as Judge Goldfarb described before, it's a factor that needs to be considered. I think it would probably take us back to the dark ages of our practice if there was a law that addressed it that blatantly, because we are a no-fault state, and almost every state is. I don't know how we could go back that way.
I think you'd have a lot of very wealthy husbands now claiming they were survivors of domestic abuse. So, could cause some problems.
I don't want to laugh about it, but that is, yeah, someone else has said the legislation is not going anywhere. They're now talking about a task force to look into this, which is, kind of how things go in Springfield. So another question that came up, so I'm going a little bit off topic again, but it kind of relates to what we were just talking about, because Kim mentioned the trauma that some clients experience when they hear a ping on Family Wizard. This particular attorney has a client with 2 young children, and she wants no direct contact with the abuser. And there's a family time, that she doesn't even want to really do Family Wizard or one of the other online apps, but they do have parenting time, so they need some kind of communication substitute. Any thoughts, anything that anyone has done, has set up that has worked in these situations? Maybe Judge Goldfarb, you might, is there anything that you've ordered that's been particularly helpful in these situations?
Well, again, in other words, are we talking about children?
Yes.
If it's just bills, I mean, Family Wizard is used to send copies of bills from, in other words, someone who even possibly has been abused has to send the bills to get those reimbursed.
Right.
But if you're talking about, I thought I did bring it up earlier, whether it's video chatting or phone, and the phone used to be a big deal. Does the child have their own phone? And if the child is too young, the parent has to have the phone. So the parent has to, you have to be, I think, set up orders or require orders to be extremely specific. It's very important. In other words, if this phone call is, if dad or mom is going to get a phone call, they don't have any in-person contact, and they have it Mondays and Thursdays, it has to be Monday and Thursday at 7:00 p.m. period. That's it. So the phone call is going to come in, and it can be expected at that time, and the other party should be able to expect that that phone will be answered. And you hear it from both sides. You hear, yeah, I called at that, and then no, but she didn't pick up the phone, so I couldn't talk to my daughter. All the time, I've heard that. It has to be very specific, so it goes both ways. And if the child is just too small, that parent has to participate, because if not, you can't have, I mean, you can, if they say, yeah, my mom will come over every Monday and Thursday to answer the phone, that's fine, but the court can't order that. Okay, so there are certain, as much as the abused party wants to cut off the other party from talking to anything with the child, it's just sometimes in the very rare situation where there's no contact at all, there are some, but most often there are not. Most often when you have little children, especially, they want to talk to the other party and set a limit. In other words, 5 minutes, 10 minutes, that's it. Phone gets hung up after 10 minutes. Video turns off after 15 minutes. Again, you have to think about the child. And I'll stop talking. What's really helpful is when there is a guardian ad litem or a child's representative of the child who can make recommendations that what's in the best interest of that child. You may or may not, judge may or may not agree with it, but it's helpful to have, and sometimes they are all of you, many lawyers that are watching here also can serve as child representatives. And it's helpful to the court to know what might be working in this particular family.
That is really helpful.
I have a comment for Elizabeth. First of all, I think our family wizard is great. I think it's unrealistic, even if someone has sole decision making as an abuse survivor, that you're not going to have contact with the other parent. And so having a platform that can be utilized and reviewed by experts, I would sort of kind of push that on my client in the most respectful way, or at least let them test it for a month. Maybe they're not comfortable doing it forever, but have your client have a test scenario with what that looks like. And it looks like that you were in Minnesota, Elizabeth, but here in Illinois, we have parenting coordinators, and maybe it's something where the parties need a parenting coordinator to help have this third-party discussion after the case in the terms of allocation judgment. That might be something that might be helpful if there's day-to-day issues that come up. I think that it also depends on the terms of your allocation judgment or your custody judgment, if that's what it's like in Minnesota, right? So you have the specifics that Judge Goldfarb mentioned, but just what is the primary parent, if that's the female survivor, required to provide to the other parent, right? Versus what are they independently required to go obtain information to try to minimize the contact between the two of them. But I often personally find it surprising when someone doesn't want to use a platform like our Family Wizard. I don't necessarily find that there's often good reasons. I think it's a very helpful communication forum.
Okay, Andrea had another comment on this kind of communications between parties.
I would agree, and I wanted to add to what Rebecca was saying on the My Family Wizard. So I had a case where I had the woman and her husband would text her like 50 times a day, and it was very upsetting and very mean tones. And I said to her, get the My Family Wizard. So I don't want to pay for him to use it. And I said, well, it's going to be the best investment you ever made. And it was, because she could get me to add on and I could see them. And when he realized that her lawyer was reading these things, he stopped. And I thought it was a really helpful tool for abusive situations. And then one more thing, I have a client that is a very serious domestic abuse victim. And she's on My Family Wizard. And for the finances, when the husband is really mad, he goes in and he changes the program. Like if it said all these expenses, here are the bills, should be split 60-40, he changes it to 50-50 and then only sends her that amount. But you can see that he made the change. So it's been very helpful to have it on our Family Wizard, because it's hard to get out of whatever you put in there. And so I found it to be very, very helpful in these cases.
And Andrea, often I tell people who are hesitant, that same way like that you can see it, you can also provide it to a guardian ad litem, or you can have third-party professionals, but also a nice thing, and not to be like, oh, just our Family Wizard, there's other programs as well, but you can have someone else help write give your login. It doesn't have to be your private email, but help formulate your emails, right? You have a spouse or a sister or a friend where maybe you don't want them to give access to your entire email account, but your Our Family Wizard, they could have your login and help help write that for you. And so I like to tell people if they're uncomfortable, they're not certain about it, you're going to still maintain some level of communication. So try it, you know, just see, even pay and log in and see what the platform looks like to give it a chance.
Great. Great. Anything else? Anyone else on that one? That was really good. Thank you. Thank you for bringing that up. I'm trying to see where we are and what questions we still have left to answer in the last few minutes here. We only have 10 minutes left. Maybe, I think I'd want to hear from you again, Kim. We haven't really touched on this too much, but oh, let me think. We talked about that. We've talked a little bit about maintenance issues and timing. And Kim, did you have anything else that you wanted to add? We had a couple of points you were going to make about what to do if you suspect your client is being abused or maybe even is the abuser. Did you want to touch a little bit on that?
I mean, I think we already talked about what to do if you suspect your client is being abused. I mean, I can say a couple of things about if you suspect your client is abusive.
That'd be great.
Yeah, I mean, so first of all, I mean, I think the reality is that you may not be able to tell when you first meet a client or even during the initial intake meeting whether someone is abusive. You know, in fact, most of the time your legal relationship with an abusive client will often mimic the same dynamic found in an abusive relationship. An abuser is likely going to initially present to you the same way he presented to his partner. It's very warm, charming, calm, rational. It's probably not until you get further into the representation that you're going to see any sort of red flags or escalations. You know, I think something to keep in mind is that, first of all, abusers often target specific types of attorneys because they want someone, either someone who is oftentimes young or inexperienced, who they can bully and manipulate, or they want someone who's very high-powered and aggressive, who will do their bidding for them and take on their fight for them. I think for an abuser, the legal system and his relationship with his attorney becomes a tool to continue the abuse. You know, he often uses tactics like trying to get his attorney to file motions after motions in an attempt to bury his partner in paperwork and deplete her financially and emotionally. Oftentimes, kids and parenting issues are used because an abuser knows that oftentimes the kids are the most important thing to her. I think that attempts at settlement with someone who is abusive are often fruitless because the real goal is not to settle, it's to keep the case going as long as possible so he can maintain access to her and continue to abuse her. You know, at the root of abuse is a need for power and control. You're often going to see escalations in your client when he feels a temporary loss of control or the case isn't going according to plan. And during those times, that's when he's going to really try to step it up to try to regain some sense of control over the legal case. And I think as a lawyer, if you suspect your client is abusive, you want to set really firm boundaries and limits with that client. Consistently remind them of the scope of representation, your role, what you're legally and ethically able to do and not do for them. You also want to check in with yourself. You know, if at any time you feel uncomfortable with something going on in the case, that's a huge red flag that something doesn't feel right to you. You know, and to always consider whether or not there is the option, either the option or even the imperative if something feels unethical, to be able to withdraw from those cases.
Great, thanks. Thanks. I think it's really important. You know, we're so focused on the survivor in this discussion, but there is that other piece, you know, of it, and who we're representing. And listen, everybody's entitled to representation, right? But how, as attorneys, we still have a choice as to how we represent our clients. And I think that for our last question, I think that ties in perfectly. So thank you so much, Kim. Judge Goldfarb, I'm putting you back on the hot seat.
Okay.
What is it that you want to see from attorneys, both ones that are representing survivors and perhaps ones that are representing abusers? I should say, more generally, what is your wish for the future for the attorneys that appear before you in court?
Okay, well, obviously you can tell I keep focusing on children. So I that's a big part. And I expect the attorneys to at least be cooperative in that respect and understand both sides, and even when the money is tight, it's, if the judge believes it's important to have somebody represent the child, that's going to cost money to this family. But it may be the most important thing that happens. You know, I actually find for the vast majority of lawyers that they really do understand what their job is. They really do understand that it's in the best interest of every family to come to some sort of an agreement. Even if they can't come to, they can sort of push it, because if it goes on and on and on, it's abusive to everybody. I mean, it's abusive to the children because I don't care how little they are, they can sense something's going on with mommy and daddy. And the older ones, and when I say older, it could be 7, 8 years old, they know what's going on because the parents sometimes don't do their best to keep them out of it or not let them hear it. So for the very most part, and it might be hard when there's a really, really very wealthy family, because when they're fighting, they're willing to spend, and the lawyers will say something, I could tell, and they'll go, I don't care, just file it. I don't care what it costs. I don't know if that happens, but my guess is it does. So I really find that most attorneys, and I just use the word most, really understand what's in the best interest for their client, for the court, for the entire family. So I really don't have any complaints. And I can just say from a judicial standpoint, if I do see something where it's abusive in terms of filing, et cetera, there's a whole bunch of things you can ask a judge to do that would really nip this in the bud, a whole bunch. And I know I don't know any of my fellow judges that wouldn't step in and make sure that things are more on a level playing field on many different grounds.
Thank you.
Okay.
Thank you. We just have a couple of minutes. Are there, it's a great way to end, but does anyone else have any last minute thoughts, something that we didn't cover? I see a chat that I think only came to the panelists, but I think it's really important. It's from our current board president, Stacey Halpern. I'm going to give her a little shout out here. And it just says that SHALVA is so grateful to all of the family lawyers who so generously step up and do pro bono work for our clients, as well as those, who may take reduced fees along the way. Thank you. We are always in need of more if you are able. And she again said so grateful. So I think with that, any closing comments from our panelists? Or are we all good? I think everybody's done an hour, another hour on Zoom of our lives. So thank you to all who attended. I will be sending out surveys. I should have put it in the chat, but I didn't. So I will be sending you an email with that. Please take a moment to fill it out. And I will be sending your certificates. So those of you that stuck with us through the end, you will be getting a certificate in the mail for an hour of, in email, for an hour of professional responsibility, as well as a general CLE credit. So with that, thank you. Thank you to all of our panelists for the time that you took getting ready for today, as well as the time today. And I look forward to seeing everyone at our next legal program, which will be in October for Domestic Violence Awareness Month. And hopefully we will be able to do that one in person. So with that, thank you all and have a good day.